Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more. All right, let's bring in Dave Workman, our buddy. We've been friends for an awful long time. Of course, a real journalist, works at the Second Amendment Foundation, does a lot of other things. Dave, how are you, sir?
Well, I'm fine, Tom. How are you doing?
I am well. It has been a busy couple of weeks ever since the Bruen decision popped out of the Supreme Court. It's like a flurry of activity, both lawsuits from our side challenging existing laws and going back and trying to challenge some of the decisions being made, but also activity from the gun ban side, such as New York saying, well, we're going to rush into law, 10 different laws, and and I was going to get you to comment on this one, they're going to require you, if you want a pistol permit, a carry permit, to turn over the information of all your social media. What's going on here?
Well, it's an invasion of privacy, in my opinion, and whether it actually is or not, that's certainly up for the legal beagles to sort out. But to demand that someone provide access to their social media material, that is beyond the ken to me. I think that it's nonsense, frankly, and all it is harassment, really. That's what it boils down to. And it moves, or if they are able to enforce it, it would move New York right back to where they started. They would have an opportunity to arbitrarily just deny somebody a concealed carry permit back there. And I think that's really what they're after.
Yeah, exactly. I mean, for those who didn't quite follow it, the whole idea behind the Bruen decision, the Supreme Court decision, was New York required you to show proper cause before you could get a carry permit. Proper cause was whatever the issuing officer thought was worthwhile, that you were a worthy person, that you were whatever it is. And almost no one got that because you didn't have, quote unquote, proper cause. Entirely subjective. And that was the whole idea, is that if it's subjective, we can prevent you from getting the permit. All of this started way back when they said, we're not going to let any black people get the permits. So we're going to have this rule. That way, no matter who it is, if you're black, you don't get a permit. And so, I mean, typical of most gun control laws, they're rooted in racism. But now they're saying, okay, well, they said we can't do the proper cause thing. We can't require that. So we're going to look at your social media post, and then we're going to use that to decide if you're worthy or if you're a good person. That's exactly the same thing as proper cause.
Yeah, pretty much. And it reminds me of what Twitter and Facebook have been doing to conservatives for a long time. Their fact checkers come in and just say, well, we don't agree with what you say, and fact checkers say there's something wrong. In this case, it'll enable some bureaucrat who's never been elected by anybody, we don't even know who that bureaucrat might be, to just hammer down and say, you know what, we don't like what this guy says either about the flag or about Antifa or about somebody
COVID
else.
Or anything.
And yeah, exactly. And because of that, we don't think he's mentally capable of having a carry permit, so we'll deny him. And that, of course, is going to be challenged in court. It's inevitable. And I hope that it comes up before this Supreme Court, because Clarence Thomas is not going to have any patience with that sort of thing at all.
Now, another one that just popped up out of California that I know that the Second Amendment Foundation is on is the idea that California just passed a law that said you can't it would actually be a crime to advertise guns or accessories or anything that's about guns to minors, anything that might even appeal to a younger person in the messages about guns. I mean, I'm just thinking, first of all, forget Second Amendment. This is a First Amendment violation.
Exactly. What it does is it impairs a lawful business, which, gun shop or sporting goods store, from doing business, from advertising whatever it is they've got on sale, even during the hunting season particularly, and any other time where there might be a sport shooting event. that would draw customers to the store. They can't advertise any of this stuff, anything related to firearms at all, ammunition, primers, reloading supply, any of that stuff. And
even hats, even hats and T-shirts. If you said, come on in and get a free hat, they said, well, kids might be attracted to getting a free hat, so you can't do that.
Well, sure. Yeah, and to me, it's a First Amendment issue, and I know you know this term as well as anybody, restraint of trade. That's a big no-no, and even if the government does it. So I think I look forward to seeing a lot of litigation over that kind of thing.
Well, you have been covering gun rights for decades, and I have to assume that this reactionary activity on the part of the gun banners out there, New York, California, and others, to double down on their restrictions on gun owners in the face of the Bruen decision doesn't surprise you.
No, not at all. I've written several times over the course of the years, and especially in the last 2 weeks, how the gun control crowd is stubborn to the nth degree. They simply do not want to give any ground at all, and it's their goal to deprive as many people as possible of their Second Amendment rights. And ultimately, I think they'd like to erase the Second Amendment from the Bill of Rights. And some of these people are fanatical about it. I look at this kind of thing as just another manifestation of just how far out in the weeds these people are emotionally and philosophically. They're just off the rails.
Tell you what, hold on a second here, Dave. I got to take a quick break here. When we come back, we'll pick this up. We're talking with Dave Workman, talking about, one of the things I want to talk about is kind of the way the media treats guns and gun owners, and I call them the PR department from the gun ban lobby. I'm Tom Gresham. Be right back with more gun talk. We're seeing a rush to pass more gun control laws that you and I would look at and go, well, these are clearly unconstitutional in face of the Bruen decision, which came out of the Supreme Court 2 weeks ago. And people ask me, they said, well, why would they do that? Why are they rushing to do that? Don't they know? And I have to explain to them, you got to understand that for a lot of these gun banners, they just don't care if it's unreasonable or even if it's unconstitutional. Their idea is we're going to pass it and then we'll let the courts work it out. Even if we are pretty sure this will be overturned, at least we can be seen, and here comes the important part, we can be seen to be doing something.
Yeah, that's a given. And symbolism is really big in the gun control world. You've seen this for years. Symbolism over substance. We've seen, for example, how the gun laws have failed in Highland Park and in Uvalde and in Buffalo and just about anywhere else where there's been a tragic mass shooting or some kind of a tragedy involving firearms. You look at it every day in Chicago, and that is a massive failure of gun control, which, of course, the other side will never admit. They go to the outer limits to try to dance around any pro-Second Amendment laws. This court ruling should have been expected, and I think it was. So what they've been doing, I think, behind the scenes is planning to figure out ways to dance around this stuff. The ruling, if anybody has not read it, you really ought to read it. 63 pages of pure genius by Associate Justice Clarence Thomas. And you can tell that he's been chomping at the bit to be able to author a pro-Second Amendment Supreme Court ruling. And this one is actually pretty good. He's done a masterful job at eliminating the two-step process and going through this business about how it's unconstitutional to require somebody to provide a good cause in order to exercise a constitutionally protected fundamental right. And it was funny, I got a message on social media here. Well, this has been about 5 days ago, and somebody was talking about how the Second Amendment gave us the right to, and I fired right back. I say, hey, the Second Amendment doesn't give us anything. It protects an existing right from the government. And now that the Second Amendment's been incorporated to the states, thanks to the McDonald ruling of 2010, which, by the way, was a Second Amendment Foundation case, the states are faced with this too. So they've got to toe the line, but they're trying to figure out how many ways they can dance around the line and cross underneath the line just to drive gun owners crazy. Because they really delight in trying to poke firearms owners, and that in itself, and that suggests to me that they may be about a half a bubble off plum. Who wants to deliberately pick a fight with somebody?
Hey, Dave, tell people where they can read your writing, okay?
Sure. I'm at thegunmag.com, at Liberty Park Press, at American Handgunner Insider Online, Guns Magazine every month in the 2A defense column, and at AmmoLand.
Or easier, just do a search for Dave Workman, and you show up everywhere, man. Well done. Thank you so much. I appreciate you being here. Thank you for your writing and your very clear thinking. I very much recommend Dave Workman's writing to anybody who's interested in this.